Good morning. Before we get started, let me inquire of the marshal. There's supposed to be a school group here from Westover High School. If they arrive, let us know, please. Council, hopefully it will not be too disruptive for the school group to get here. When they get here, to come on into the courtroom. Mr. Marshall, please just let us know. Our next case is Gvest Real Estate, LLC versus JS Real Estate Investments, LLC et al. And we will hear from the appellant.
Thank you, Your Honor. Rex Morgan from Mecklenburg County Bar, representing the plaintiff in this case, or appellant, Gvest Realty. Your Honor, this case flows from a company by the name of Yards at Noda, LLC. That company opened or was created in 2012 to operate, develop, manage a large apartment complex in the North Davidson area of Charlotte. Mr. Raymond G. found the property. He had previously had dealings with Mr. James Shaw, and actually had some dealings at the time with him. Mr. Shaw liked the property. Mr. Shaw talked with a partner of his in another business by the name of Tyson Rame, and
Counsel, Mr. Clerk, if you would stop his time, please. Are they here? Okay. We'll just take just a moment and let them come into the courtroom. But obviously, you'll be able to start back where you were.
well, can I reserve 5 minutes for rebuttal? I forgot to say it at the beginning, so I apologize.
No, that's fine. If you want to sit down, you're welcome to. Good morning. The court wants to welcome teachers, students from the Law and Justice class from Westover High School, Fayetteville, who are joining us in the courtroom today. We appreciate your being here. Oh, sorry. As I was saying, the court wants to extend a warm welcome to the teachers and students from Law and Justice class from Westover High School, which I believe is in Fayetteville, who are with us today. We thank you for being here. The case you're fixing to hear has to do with businesses. North Carolina has a special type of trial court that handles business disputes. It's called the business court. And the appeal that is being discussed by counsel today has to do with the decision of the trial court below, and of course has come directly to the North Carolina Supreme Court. With that being said, counsel has already begun his argument, counsel for the plaintiff, and he will continue at this time.
Thank you,
Mr. Morgan? Yes.
Yards at Noda developed the apartment complex in Charlotte. It got built by late 2014. That was phase one. Phase two had been planned to begin in 2015 and end in 2016. Phase one's 182 units. Phase two was 160. Mr. Shaw and Mr. Rame started having some disputes amongst themselves in late 2013, 2014, not really related, more internal, and disputes concerning their other companies. They decided it would be best if they split apart. So they actually signed a document in April 2014 splitting their interest, but they kept Yards at Noda the way it was. And Yards at Noda was owned, the members in the company were the plaintiff, Gvest Real Estate, which had 25%, the defendant, JS Real Estate, that's Mr. Shaw's company, and TR Real Estate, that's Mr. Rame's company, each had the remaining 75%, which they split equally. Moving forward into 2015, plans were being made, Gvest thought, to build phase two. And the evidence shows that. But in June 2015, Mr. Rame and Mr. Shaw were served with a civil forfeiture action by the U.S. Attorney for the Northern District of Georgia. And that was in connection with a money services business that they operated in Atlanta called Sterling Currency. The civil forfeiture froze everything. Every company that Gvest or Mr. G had that was related to either Mr. Rame or Mr. Shaw stopped for a while. All accounts were frozen, and nothing happened for several months. Mr. G and his companies were dismissed from that lawsuit after the U.S. Attorney determined that neither he nor any of his companies had anything to do with Sterling Currency. 2016, early part, the U.S. Attorney sent down a criminal indictment, came down against Mr. Shaw and Mr. Rame for a number of federal charges. And that's one reason when you look at the documents in this case, you see it's a 2016 filing that didn't get any sort of dispositive motion until 2023. There was a 4-year stay from 2018 to 2022 while Mr. Raymond, Mr. Shaw dealt with the criminal charges. They were convicted in 2018. They appealed. The appeal finally got over and done with, and they're in prison now somewhere. We don't know where. This case essentially, we have two issues that we're dealing with today. One, the court granted summary judgment on our claim for declaratory judgment to determine who exactly were the members and interest holders in Yards at Noda. And I'd like to address that first. That is based upon the original complaint was filed. We noticed that Mr. Shaw was the tax partner at that time in the company. In 2014, Yards filed an amended tax return in response to a complaint from my client, Mr. G, that, well, now I have to go back to the facts a little bit. In August of that year, August 2014, Mr. Rame and Mr. Shaw decided that Mr. G should no longer be a manager. Since he had found the company and he was participated in the development of it, he was named a manager with Mr. Shaw initially. In August of 2014, however, and it's in the complaint and an exhibit, Mr. Rame and Mr. Shaw replaced Mr. G as a manager with Mr. Rame. And Mr. G didn't really fight that. He, at the time, he admitted he wasn't getting along well with Mr. Shaw, and that wasn't that big an issue. But what became an issue was the 2013 tax return, which when Mr. G got it, he looked at it and saw that his interest in the company had been reduced unilaterally without telling him about it, except he saw it on the K-1. His interest in the company had been reduced from 25% to 16%. He complained about that. And eventually his complaints, someone heard it, or Mr. Shaw or Mr. Rame talked to somebody, they filed an amended tax return. The amended tax return for 2013, filed in 2014, and the accountant, it's October of that year, reversed that. Mr. G got his 25% back. But interestingly, that same tax return showed different members in Yards at Noda. Instead of it being JS Real Estate and TR Real Estate, the members in the amended return were Shaw Capital and Guarantee and Trinvest Partners. Trinvest is actually a company that Mr. Rame had. It's the predecessor company for Levin Capital. Because you'll see the same tax returns in 2014 and 15 show Levin Capital. It's really the same company owned by Mr. Rame.
So can you help me understand, is your argument that there is a genuine issue of material fact, or that on the record that was before the trial court, your client is entitled to summary judgment on this question? Which are you arguing?
We're arguing that's an issue of fact.
So what is the disputed fact that the court couldn't resolve at that time?
The disputed fact that we contend is that there's evidence, substantial evidence, that there was a transfer of entities by Mr. Shaw and Mr. Rame. And that's contrary to the statute. And if they did it right, and that's the whole defense on the defense side. The defense side says, well, we wanted to make the change, but we just didn't do it right. And there's the dispute on this issue, Your Honor.
But I guess what I was saying is that I guess the actual transfer would be something that is an operation of law. So what specific fact are you saying a jury or some fact finder is going to hear and decide in your favor? They say this happened, you say no, this happened.
We begin with a statement made by Mr. Shaw, who the law requires to follow the operating agreement. And since he signed the operating agreement, he's deemed with knowing what's required to make that change in entities. He swore under penalty of perjury that the entity had been changed in that amended return, which shows Shaw Capital and Guarantee and Trinvest as the new entities in the company. Now, if he followed the law and knows the contents of the operating agreement as he's required to, we contend that that's substantial evidence that the transfers were made. The issue with the court and with the defense is there is a section of the operating agreement, section 6, and in particular, I think 6.1.1.2 states that there has to be a written signed statement from the new company or the new entity to follow the operating agreement. That's essentially what it says. Well, here, we don't have that. We admit we don't have it. We haven't seen it. But we contend that the statement under oath by the man who controls the documents for the company, stating that it was made and that the transfer was done, we contend that that's substantial evidence that the jury needs to hear to decide the credibility and the weight of that statement under penalty of perjury that the transfer was made. The trial court, and the trial court judge is excellent. We have no complaints with the trial court judge. We believe that he missed this one because it is substantial. Every case we found in North Carolina that deals with tax returns finds that the evidence in them, because of this solemnity, I'm sorry, I'm getting a dry mouth, of the returns, is substantial. The Eggleston case, which we put in front of the court from 1948, the court gave lip service and specifically said those first returns, which showed Miss Eggleston as a partner, should not have been withheld. They should have been put in evidence. The court had more of a problem with the amended return that Mr. Eggleston did, where he removed Miss Eggleston as a partner in the amended return. In this case, that's the issue on whether there's an issue of fact. And there's backup to that same sworn return in 2014 and 2015 returns. The 2015 one, that's the one we even have Mr. Shaw's signature to the sworn statement. And of interest, the 2015 return was filed in 2016 after Mr. Shaw had been indicted criminally for wire fraud, mail fraud, and money laundering. The money laundering charges, he was found innocent of that. But the wire fraud and mail fraud, he was found guilty. That return, and it is Doc Exhibit 799, Your Honor, was filed September 15, 2016, subsequent to the criminal indictment of Mr. Shaw and Mr. Rame in February 2016. We would contend, and it's a a jury argument, but nonetheless, we believe Mr. Shaw would have been on his P's and Q's at that point, being under indictment and not yet tried, and he wouldn't have been filing a tax return contending under oath that the wrong companies were the members of Yards at Noda. So there's where the issue is with the trial court, and keep in mind, it's a declaratory judgment action. There is a specific provision, Section 6 of the operating agreement, that has to be complied with in order to make a transfer. We admit that. The only two of those do the defense really attack. One is the prior existing agreement. We don't have a prior existing agreement, but we have a lot of documents, and the court even discussed them. There's a document signed by Mr. Rame. We don't know when it was signed. He doesn't know when he signed it, stating that he was agreeing to the transfer of his entity. That's the written consent of managers that he signed, and the court made reference to it in its decision, but not knowing when it was signed or the circumstances, no one has really come forward with that. The court didn't give it much credit. I understand. We understand.
Counselor, I'm so glad you raised, I believe you're referring to 6.6.16. The transferor has obtained the prior written consent of the manager, which consent may be withheld in the manager's sole discretion. If I recall, the business court made a point of the fact that the manager was defined earlier in the operating agreement to be both Mr. G and Mr. Shaw as, quote, the initial manager. And from what I understand, Mr. G has conceded that he did not sign or did not consent to this. So how can we reconcile that?
Mr. G, you're correct. The reconciliation is that we know that Mr. Rame has signed his permission somewhere along the way. We don't know what Mr. Shaw signed, but we contend that his position as the tax matters partner and his signature to penalties of perjury that the transfers had been made with his obligations to follow the law and follow the operating agreement are sufficient evidence for a jury to decide the credibility of that question. We don't, and it's not as if Mr. G had the documents. The documents were controlled by Mr. Shaw and Mr. Rame. Mr. G, after August 2014, had no access to them. Matter of fact, reading the complaint, and I know it's long, but you know, Mr. G spent a year trying to get the documents that he was entitled to by statute, and it took filing the lawsuit to ever get Mr. Shaw and Mr. Rame to turn over anything. So we don't know exactly what Mr. Shaw may have signed, but Mr. G was not controlling the documents on that. But if Mr. Shaw did sign anything to approve it, or as the manager, if he decided that it's okay, I approve, and I gave his approval, perhaps not in writing, maybe it was in just an email or something. That's enough, we think, or at least a jury should be able to hear the testimony, especially when, if you look, we've combed the defense documents. There's no denial in there from Mr. Rame that they failed to comply with the requirements of Section 6. There's no denial in there from Mr. Shaw that the transfers failed to comply with the requirements of Section 6. the closest either Mr. Rame or Mr. Shaw get to any denial of the transfers occurring is in Mr. Shaw's deposition, where I asked him about the operating agreement amendment that Mr. G signed before he knew about all this, and asked Mr. Shaw if he was aware that I'm going to introduce another name, I apologize, but it's Mr. Shoemate. That's someone that worked for Mr. Rame. Asked him if he knew anything about Mr. Shoemate presenting that document to Mr. G for signature. Mr. G signed it.
Well, and Counselor, your time's growing short, and I have one other question I'd like you to pivot to because I believe your friends on the other side are going to address it, and I'd like for you to have the opportunity. I understand that you are advocating for us to overturn North Carolina law regarding fiduciary duty, but I am anticipating that they may be arguing that that argument is not preserved. Do you have a position with respect to that?
Yes, that's one reason we produced the transcript. We argued it extensively about the majority ganging up on the minority in this situation, and the fact that there is an explicit agreement that's been signed between Mr. Shaw and Mr. Rame that essentially excludes Mr. G from ever being able to vote for the manager of the company. They both, the agreement and
Well, and sir, if I might point you in the direction of what I think they're going to argue, it's not whether there was a breach of fiduciary duty, but whether North Carolina recognizes such a duty and whether it was preserved, because we can't get to your second point unless you can help us with the first point. So if you would let us know.
I would argue on the recognition part of it that it agree. There's nothing in the North Carolina LLC that specifically addresses fiduciary duties between the managers directly to Mr. G.
But what about the fact that I'm anticipating, based on their briefing, that they're going to argue that that's not preserved, you did not preserve it? I think you were beginning to answer that question, but if you could be, I guess, a little clearer for us.
I would refer the court, I think that the page numbers in the transcript are 9 through 14, where we were asking the court to recognize that the majority here, this majority coalition, had expressly agreed to limit Mr. G's ability to participate and in effect had amended the operating agreement in that respect.
And so, if I might, what I'm hearing your argument may be is that since you specifically argued that there was a breach of fiduciary duty, notwithstanding the fact that one has not been recognized, that that would be enough to preserve your claim here, or to preserve your argument.
Yes, we were, and the position that we were taking was more in line with just the duty of the covenant of good faith and fair dealing in any contract. It's always implied that when you get together as managers and members of the company and agree that we're going to have this explicit agreement, and if you ever vote against me, I can go get an injunction, and the same goes for you, where you're excluding a minority owner and did not share it. Mr. G didn't know about that agreement until after the lawsuit, so secretively, all of the public policy reasons that courts want to talk about, LLCs, creature of contract, whatever, we understand and don't really have a fight with that. But you cross the line when you start having a coalition with secret agreements that in effect amend the document that Mr. G signed as the operating agreement. And I know I've crossed over. I'll cede the podium to opposing counsel. Thank you, Your Honor.
Thank you. We'll hear from the appellee.
May it please the court, Chief Justice and Associate Justices. My name is Chelsea Corey on behalf of Appellees. I think it's efficient to jump to the merits. I'll start with the declaratory judgment claim, and I think there's some kind of confusion about the conditions of transfer arguments. So I think the parties agree that the 6 provisions in Section 6 of the Yards Operating Agreement all have to be satisfied in order for a transfer to have occurred. And Justice Barringer, I think you hit the nail on the head with Section 6.1.1.6 that says the transferor has to obtain the prior written consent of the manager, which consent may be withheld in the manager's sole discretion. So this is obviously the largest area of dispute, and I think it's arguably the easiest one. The transfer purportedly took place in January 2013. At the time, there were 2 managers. It was Ray G. and James Shaw, and there is no dispute amongst the parties that Ray G. did not consent to this transfer. So 6.1.6 definitionally has not been satisfied. I think
And before you move on, if you would clarify, if I understand his argument, since one manager had at least ostensibly agreed, because that's why they'd like to get to the jury, and he doesn't know exactly what has been signed, is your position it takes 2, or that it was never signed at all, or clarify that position?
So I think it's both, essentially. I think it does take 2. I think under the terms of the operating agreement, which is the agreement that all the members agreed to when they formed the LLC, it takes both. 2 managers were elected and existed and defined, and manager, very clearly both have to be in agreement. I also think that it's undisputed that G did not consent, and I think that we dispute that James Shaw consented in a way with the prior written consent that's required under 6.1.6. So I think both have to be satisfied and both haven't been. And I think for that reason alone, it shouldn't go to a jury, because it just cannot be found as a matter of law that Section 6 has been satisfied.
So I understood your friend to be saying, I'm paraphrasing a little bit, but essentially that a jury could, you sort of have some sort of presumption of regularity that exists in the corporate compliance context, where a jury could infer, even in the absence of direct evidence, that something occurred because it would be consistent with having complied with a series of other documents and tax requirements and other things. And I'm not aware of that principle in our jurisprudence, but what's your take on that? That creates the fact issue, because the jury could infer that if they got back there and started thinking about it.
I think that is a bad inference. I think that you shouldn't, when there are clear provisions that all the parties agree to that have to be satisfied in order for something to happen, I think there needs to be evidence that those things happened. And I think in order for a jury to reach a supportable conclusion, it needs to be relying on evidence and not inference. Otherwise, yeah, I think the general thesis of our argument more broadly is like words matter, and the contract, the Yards Operating Agreement that everyone agreed to matters, and it should just be followed. And I think, so at least with respect to the conditions of transfer argument, it's our position that 6.1.1.6, mouthful right there, is not satisfied. But I also think that there's not evidence that 6.1.1.2 or 6.1.1.5 has been satisfied, in addition to the fact that, as we argue in our brief, those arguments have been waived. So, each of those has very particular agreements or requirements. It says, the transferee delivers to the company a written instrument agreeing to be bound by the terms of Section 6 of this agreement. That does not exist. So, with respect to the satisfaction of the conditions of transfer, they simply haven't been satisfied. And I actually don't know that we have a live dispute about that. And I think that's where appellant's declaratory judgment fails as a matter of law, and Judge Conrad properly decided it. I think the other point to be made about the declaratory judgment action is that under, I think, the only logical reading of the Yards operating agreement, a member cannot transfer the entirety of its membership rights via Section 6. At the best, they transfer an economic interest, which is defined in the Yards operating agreement, capital I, interest in that agreement. When you think about kind of the words on the page, and I'm happy to kind of go through it, but it makes sense. It enables the members to transfer kind of the financial benefits or hardships, depending on how the business is going, over to someone else. But the members remain the same. And the core members of the LLC agreement that vote on matters and whatnot all remain the same. And I think Section 6.2 of the agreement is absolutely clear that you cannot withdraw from membership of Yards voluntarily. And so appellant's reading of the Yards operating agreement would essentially moot Section 6.2 altogether, because the declaratory judgment that they're asking for is it's a reversion to the North Carolina LLC Act, which says that if you transfer all of your economic interest away, you're no longer a member of the LLC. But the Yards operating agreement explicitly contravenes that default rule, and under the LLC Act, the operating agreement controls. And so in this case, even if we're living in a world where all the 6 conditions of transfer were satisfied, all that's been transferred is an economic interest and not the voting rights that are attendant to membership rights. And that's not the declaratory judgment that they're asking for. Because at the end of the day, all of the voting rights would remain with JS Real Estate and TR Real Estate, and G's removal as manager would be, consistent with all of that. So it's our position that the court decided correctly the declaratory judgment claim, and that there's no issue of fact with respect to whether those conditions of transfer have been satisfied. They have not. So I think to pivot to the potentially more interesting question, simply because it's involves a kind of request to overturn North Carolina, kind of settled North Carolina law. We do think that the argument is waived. We think that raising it, if you look at the transcript, it's in response to Judge Conrad's kind of thoughtful questions at the summary judgment hearing. That argument was sort of presented on the issue. It's not in the briefing on summary judgment. But I think irrespective of waiver or not, I don't think that this court needs to overturn settled North Carolina law today. I also think that the North Carolina LLC statute gives the clear instruction here. I mean, it emphasizes that freedom to contract is paramount, and that the flexibility provided by an LLC is kind of its main characteristic. There are good reasons to choose to be a corporation, a closely held corporation, and there are good reasons to choose to be an LLC. And when people form businesses, they use their reasoning and make a decision about the type of company that they want to form. And there are base rules that apply to corporations, and then there are base rules that apply to LLCs. And these companies did not want Yards at NODA to be a corporation and have the kind of base fiduciary duty obligations that are often imposed by kind of precedent to apply to their kind of interactions. Now, there's we've collected it on page 28 of our brief, I think, a long history of not recognizing a breach of fiduciary duty action when all of the members of an LLC are minority members. And it really boils down to, you agreed when you formed this LLC that with respect to certain actions, you might get outvoted. And there are very clear provisions in the Yards operating agreement that says sometimes all 3 members need to vote and needs 100% approval, and then sometimes less than 3.
Well, Counselor, could you for us, help me understand or deal with the argument that your friend on the other side, I believe he said, he's actually saying, and I think I've got the words right, that your your clients ganged up on his client, and that would be the reason or a reason for us to, if we did decide to recognize a fiduciary duty, to actually find that one had been breached.
Yeah. So, I mean, our position on that is the document that he's referencing is executed by two entities that don't have voting rights. So, an agreement to vote in a particular way amongst people who don't have voting rights is a nullity more generally. But in terms of the larger proposition, I think if you agreed in an LLC agreement that certain actions could be taken with a majority of votes that is larger than the share that you hold, then you know that people can gang up against you and vote against you. And that's just the agreement that you came to, right? There are plenty of LLCs where there are majority members that have 60% and they can never be outvoted. And, you know, they have preserved their position in the contract that they agreed to. And that's what the North Carolina legislature wants to be available to businesses in North Carolina to be able to come to those agreements themselves. And so, you know, the sort of gang up nefariousness of the term, is it really ganging up if you're just exercising a right that you've got?
I think the argument would be ganging up may not be the most articulate way of describing it, in the sense that you have three people who came in all as minority members, and this is not a person saying, I understand I'm a minority member, I can be outvoted. This is those other two making a contract that they can, even if one of those two decides, no, Mr. G is right, this other manager needs to go. Isn't that inherently oppressive and sort of driving the growing body of law that's starting to recognize that this kind of manipulation from against fair bargaining and negotiating is problematic?
Yeah, I mean, I can acknowledge sort of the general premise. I also, you know, as I started out, I don't think that is exactly the situation here, but I also think the growing body of law is informed by statutes that legislatures are enacting, and we don't have that statute here. And I think that's relevant, you know, to the analysis, because, you know, if other legislatures decide to enact greater protections for the members of their LLCs in their state, that's a perfectly reasonable legislative objective, and I just don't think that that's the situation that we have here. And until the legislature acts in a way that certain other states have, you know, I don't see a reason to kind of overrule and broaden both the North Carolina Act, LLC Act, and the prior law on the issue. And so, you know, that's sort of and that's actually a large majority of the cases that they had cited are in states where, like, there are statutory duties to do that. And, you know, some of the other, you know, kind of more traditional New York and Delaware have opted to, you know, enact legislative protections for the, you know, general concern about oppressive conduct. So I think I've done a land speed record and made it through most of my time.
Let me take you, before you wrap up, real quickly back to, I think what we all kind of see is maybe a more mundane question, but back to the summary judgment standard.
Love it.
I just want to make sure that we are consistent with our law. So let me frame this for you and tell me if you agree with this, that you would agree that if there was evidence that said of a person saying, I intend to do X, and then there was some factual thing that would need to take place for X to happen, and the evidence is a person saying, I intend to do X, and then the evidence that X happened, the jury could infer that the person must have gone and done the thing in the middle, even if there's no evidence that happened. Because that is a reasonable inference. If that thing would have to happen for the result, and so you have, I'm going to do it, and then it happened, that you can infer the middle. Would you agree with me about that?
I'm just, I'm thinking of your hypothetical, because I'm not sure that I agree with the final premise that it happened,
Well, that's
right?
what
Yeah,
that's the
exactly.
point I'm trying to make. Is
Yeah,
what maybe the problem here is it's I'm going to do it, and not only are you asking the jury to infer the middle, you're asking them to infer the very end as well, because
correct.
there's just no evidence here
Because the
of any.
middle dictates the end, right?
Right.
It's more
So
like a road that you have to travel to arrive at the other destination. Like, I suppose if we live in a world where there's no physics and somebody like appears at the other end, okay, but I don't know. It just, to me, they're conditions precedent in a contract. And so, I think our body of contract law says those conditions precedent have to be satisfied in order for the thing to have happened. And I'm not even sure that they disagree about it on that piece. And so I think, the only kind of final thing we do have a motion to dismiss because we viewed kind of honestly a smidge of a gap in the kind of appellate body of law in terms of whether a final judgment is absolutely final on the facts sort of presented to us. And I think other jurisdictions have sort of handled this in different ways. And, admittedly, it's sort of confusing. But, to remind, all of plaintiff's claims had been dismissed on summary judgment by Judge Conrad. And then after the fact, we dismissed our counterclaims without prejudice, right? And they sort of cite to case law where these where courts of appeal, not the North Carolina Supreme Court, but North Carolina Court of Appeals has taken up cases on that posture, presuming that it's final. We would posit there's actually no motion challenging jurisdiction in any of those cases. And I think that the question becomes, under the kind of relevant rules, is a admittedly interlocutory partial resolution of the claims by the court transformed into a final judgment after the opposing party dismisses the remaining claims of their own accord, because it's not an order that's entered by the court after we dismissed our claims. And I know it's a technical ticky-tacky argument, and I think that this case should be decided on the merits. And so that's why I want to lead with the merits, but I didn't want to go and not address it because it is a motion in front of the court. So if there's no further questions.
Thank you,
Thank you.
counsel. Rebuttal.
I'll be brief. The transfer that was made, as reflected on the tax returns, is the entire economic interest. Counsel's statement that we can't show transfers, I think her statement was, you didn't comply with the 6.115 for the tax return, tax number, but they're on the returns themselves. So when the transfer was made, someone had to supply the tax number of the new companies for Mr. Shaw and Mr. Rome. Those same tax returns show that 100% was transferred of the economic interest. Consequently, under statute in North Carolina, Mr. Rame and Mr. Shaw's companies became interest holders. And that gets to the focus of the lawsuit. This company, nothing is happening now. The two owners of the majority, 75%, are in prison. It's not part of the case itself, but something needs to be done. And we believe when you look at the documents and you look at what Mr. Shaw has said under penalty of perjury, those transfers were made. It's not just, and I understand, it's not just saying to someone, hey, I did this. He said it under penalty of perjury at a time when he was subject to jeopardy also from pending criminal charges. I don't know that I need to address the motion to dismiss. It's, there's tons of case law, and it's all deals with Rule 54 and its interaction with Rule 58. And this, I know this court's never addressed it specifically, but, oh, that's the yellow light. You've never addressed it specifically, but you've taken up a lot of cases where the voluntary dismissal of the remaining claims turned the summary judgment decision into a final judgment. That's because it was interlocutory and could not be final until the remaining claims were gone. Thank you, Your Honors.
Thank you, counsel. Sorry.
All rise. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be at recess for 30 minutes. God save the state and its honorable